By putting it through to us, it's not a matter of police coming along and watching you do a citizen's arrest. It wouldn't, to me, that's not the way that I see it.
No, but if you were taking it over completely, or that you were actually doing these, what it is if I have someone who is resisting arrest, perhaps it's not you, but I do wish for a police officer to attend and understand that I am carrying out a lawful arrest. Most police don't understand.
I know that you can make I know citizens can make an arrest,
yeah.
And that our APMs or our guidelines are then to assist that person.
Yes.
You're still the person that's to sign the charge book and everything at the watch house.
Yes.
And I know that can be called upon. But the difference between that is you normally go to the location, you make the arrest, the police get called to you.
Yes.
The police don't go with someone.
No.
Because if that was the case, you wouldn't be, there's no requirement for you to be making that arrest. The police should be making that because the process is make a complaint, have it investigated. With this here, I wouldn't go on and make an arrest at this stage. With the complaint, and I know we've spoken at length, I would still want to wait and get for a complaint to come in. Then while you're having a complaint there, the lawful process then is that can the QPS then make a lawful request for those recordings? Because if the recording comes back and validates what you've said, well, then it becomes an issue, and I still don't know whether state or federal should be looking at it, but it's there. I know you've quoted there, but
yep.
in saying that, I understand you're not a lawyer. I certainly don't put my hand up having a law degree.
Sure.
But our operational legal advice team, they've got their masters in it and PhDs. We're guided by what they come back, and obviously I've got a chain of command to follow. So if it comes back and says, no, that's a lawful process, yes, we can be involved, and it might turn around and they say, no, we're going to have State Crime Operations Command, which is in town. They will take on this case, they will process it.
Sure.
And the fact that you're making allegations against a senior person in the judicial system, I would imagine they wouldn't want a junior person. I'm a senior sergeant. I would imagine they might even look at a commissioned rank to look at it. And I say that because if serious allegations against police, they normally go for a commissioned officer to be the investigator, arresting officer. But there's nothing stopping me to put the actual complaint forward, and that's what I'll plan on doing for you today.
Yes, but here's a question for you. I know that we're not both lawyers, but if you in a federal building, if you were walking in there and you saw a crime happening, yep. Or that you got called because a crime was happening in a federal building,
intervene there and then.
You would have to intervene.
Yes, but what you're saying here is I don't have to go and arrest her right now.
Oh no, I'm not.
What I'm saying is I've got to substantiate the charge.
Yes.
I don't just, because I haven't witnessed her, not issue you an order.
Yes.
The first thing we would do is ask...
Is confirm that order, that's correct.
And the easiest way is, can we copy the recordings? They say no. We'd do it in writing. Can we have a copy of the recordings? No. Well, then the process is, can we law, and that's where I've asked the operational legal was, can I take out a search warrant?
Yep.
Is there a lawful means for the Queensland Police to get a copy of that search warrant if we investigate that? Yep. The first question they'll have is the Queensland Police the one to investigate it? Well, from your interpretation of legislation, it would mean we should be able to investigate it.
Well, the thing is let's say I commit a crime or somebody else commits a crime using a federal telecommunications line.
Yep.
A police officer, a state police officer, will deal...
But if say you were an international terrorist doing that...
Oh, well, yes. Well, then,
so what I'm saying is there may be a specified, there might be a specific unit or task force, it may be international, which, again, it comes down to who is the best group to be working on that.
There is no legislation.
It's not legislation, it's just a process in law enforcement. True. We're not saying it doesn't get investigated. What we're saying is you don't, if there's a murder, you don't call in a constable from traffic branch to come in and investigate the murder.
True.
And that's all I'm looking at is I'm happy to do it if legally and operationally I'm allowed to, I'll investigate it.
Well, after I show you the recordings that Federal Kim Dwyer is assisting by in collusion with the magistrate, in that she fails to allow, even if that she does have 100% proof that recordings are altered, that she has no intent at all in investigating a federal magistrate. That means that the upper echelon is protected by the federal police.
That's what she has. Well, that's the recording.
That's the recording.
And that's why I'm saying I'll put it through my Queensland level. We'll put it in. We'll see if we can get records.
Yep, good.
So that's where we'll stand there.
Yep, okay. Exhibit I is the court order made by Federal Magistrate DMAC on the 17th of February 2012, where the magistrate still will not remove herself. Now, that's the 17th of February 2012.
Yep.
A couple of days ago.
Okay, yep. So she's issued one.
Yes.
Is that after she's received notice of your private action?
My indictment was in January, that she received that official indictment, and she is continuing in issuing court orders now.
A court order for you? So she's issued a court order against you?
Yes.
After she's been subpoenaed?
After she's been criminally indicted. She is refusing to remove herself from these proceedings.
When did you do the indictment?
I did the indictment on the 29th of January 2012.
Do you know what their return date was? Do you know when they served it on her?
I served it.
You served it personally?
Yes, I served it personally on the 29th to the registrar, Registrar Spinks, and I did...
Spinks, was it?
Spinks, Spink, S-P-I-N-K, Registrar Spink, and I did his and Mr. Cotter, who is the head of the administration.
Yeah, no, and so she's now issued on the 17th of the 2nd an order after she's been served in court. And has that order changed since the previous one?
No, she's trying. I had an application into the court to do a remedy to the situation, and she is still trying to, even though she's under indictment, that she's still refusing.
There's a stamp on the
Yeah, there's a stamp, yeah.
I have to put it on.
Sorry.
So it's just that when we asked, when I first spoke with you on this, the order that comes through, there was no stamp.
From the courts?
Yes.
So I was still trying to seek remedy from the courts as to what has happened with Federal Magistrate DMAC. Magistrate DMAC...
So is this saying you didn't appear on this day?
I'm not going to appear in front of Federal Magistrate DMAC for her to alter transcripts or commit any further crimes against myself.
So everyone didn't appear?
That's what it's stating.
It's 2011.
Yep, so the children's lawyer didn't appear, the mother's lawyer didn't appear, the mother's lawyer didn't appear, no one appeared, I don't think.
That the applicants filed 22 and 28 be dismissed.
Yep, I had 2 applications to the court for several remedies, and each has gone to Federal Magistrate DMAC. All the registrars, everyone knows that she's under indictment and that she is still trying to cause further harm to me, knowing that she's under an indictment. And she knows that I have confirmed actions of having manifested biasness and apprehended biasness, and she still fails to remove herself from the proceedings. I do believe that she had hoped that I would turn up and try and perhaps coerce me into something that I don't want to do. I wish to carry out this procedure, and I do wish, once there is the exposing of crimes, for police to witness everything that happens in that federal court, because I'm scared for my life in going back to that court.
Yeah. That does seem very...
Terrible.
Look, to me that's unusual.
Extremely unusual.
But again, I don't know how family law works.
If someone's under criminal indictment, can they still...
well, innocent until proven guilty.
Yes, but does that mean they can still make decisions and feel that they're unbiased?
Well, say if it was a real estate person, if they were under indictment for defrauding a potential buyer, can they still go and sell another house? The answer,
yes.
I would say, is yes. So she's, and I know you don't like to hear this, Magistrate Denmark is innocent until the contrary is proven.
Yep.
So she is maintaining, clearly, she's making no comment as to criminal charges. She's maintaining her role as a federal magistrate.
Yep. I am not going back to the court. I do not have to do while there remains fraud on the court, which by criminal indictment is evidence that I wish to expose. Exhibit B also, I have received another court order, and now they're trying to do a property settlement when they understand the law, and the law is that when there is fraud upon the court, that they cannot deal, and this is in accordance with the Magna Carta that this comes down from, is, and I found it within the Family Law Act, was, and I'll just find it for you, exhibit. Yep. Under Family Law Act 1975, Section 7A states, Chapter 2 of the Criminal Code applies to all offences. Oh, I apologise. No, sorry. 79A, setting aside of orders altering property interests. 1. Where an applicant by a person affected by an order made by a court under Section 79 in a property settlement proceeding, the court is satisfied that A. There has been a miscarriage of justice by reason of fraud, duress, suspension of evidence.
But see, if the court hasn't accepted those, that there's a miscarriage, they can continue. So by this process here, you would have to assume the court is not satisfied that there's been a miscarriage of justice.
Until such time, it's already been registered, the actual indictment.
It's been registered, but if the court doesn't believe that that's a valid action, they can continue on.
It's already in a court that, and a court is not satisfied that that crimes did or didn't exist. The lawyers tried to have it thrown out. They could not confirm if I was vexatious. They had no reason to believe or state that I was vexatious, and so it is going to proceed to a mention, and now I can subpoena the recordings. However, if I subpoena the recordings, I believe that they are going to come back and say they're missing, or that they're going to deny it, or that I'm not allowed to even see those recordings. They're going to find some reason that I am not allowed to see those recordings for them to win. And then, without those recordings, I haven't got most of the indictments. I have got no proofs until those recordings.
So on the 20th of this is interesting. It says on the 17th this went before Registrar Stoneham, but it was prepared on the 20th.
Wow.
3 days later.
That can't be right.
Well, something's not right.
Because an order has to be actually...
The order's on the 17th, but prepared on the 20th.
No. That...
So, P4, it's all on the same number, yeah.